Good morning, everyone. Welcome back to our weekly webinar series. Today, we are continuing the discussion that we started last week, and we will continue discussing the various important Supreme Court judgments and important issues. We discussed five judgments in the last session. So we'll continue that. And today we have some very, very important judgments that we will talk about. Over to Anil, sir.
Thank you, Ankit. So this is our 40th episode from AAA Group. I'm Anil Goyal along with Ankit Goyal. We are conducting this along with our other partners and some speakers from outside. This is the 40th week that we are continuously conducting these webinars without any fail. So it gives us pleasure. Today the subject is landmark judgments of Hon'ble Supreme Court given in the year 2022 on Insolvency and Bankruptcy Code. Today is part 2. Part 1 was delivered on last Saturday at 11 a.m., which is our scheduled time every week. And we will start today with a much talked about landmark judgment, which is Rainbow Paper Private Limited. Just allow me to share my screen. I hope, Ankit, this is visible. Is it visible, Ankit? You are not audible to me.
I'm saying perfectly visible.
Okay, I think you should. What is the difficulty on the computer? You have to just check.
I think I was just muted for a few seconds.
Okay.
That should.
Great. So, a state tax officer versus Rainbow Paper Limited, delivered on 6th of September 2022. This judgment has created a lot of uproar in the insolvency practice. So let us see the facts of this case. The corporate debtor in this case had some outstanding tax dues, which was pertaining to year 2011-12, and the recovery process also started in 2016. That is much before the insolvency started, much before the commencement of CIRP. And in 2017, in 12th of September 2017, the CIRP also started. And in 2018, during CIRP, the assets were attached by state tax officers to recover their dues. See, however, the resolution professional did not accept the claim. No, the claim was also not filed, but then the attachment, all these intimation was given to RP. The RP also saw the amount outstanding in the books of account. So this particular subject was not dealt with in the resolution plan. The state tax officer challenged the resolution plan, which was also approved by NCLT, saying that the resolution plan is not compliant to law, as the dues of state tax officer has not been considered in the resolution plan, although this information was available with the RP, and RP has ignored this information. Now, the NCLT rejected the application. Similarly, NCLAT also rejected the appeal. So the government of Gujarat, in fact, stated this was based on section 48 of the Gujarat Value Added Tax 2003. This is, we will call the GVAT Act, which provides for first charge on the property of a dealer in respect of any amount payable by the dealer on account of the interest, penalty, or any due. And the NCLT held that such section, like Section 48 of GVAT Act, would not prevail upon Section 53 of the IBC. So what is in Section 53 of the IBC? Because one is there is a secured creditor without any reference to financial creditor or operational creditor. The word used is only secured creditor. And the second thing which actually is dealt with Section 53 is there is a separate priority given to the dues of statutory authorities, such as the amount payable to consolidated fund of a state and amount payable to consolidated fund of the central government. So these were the dues payable to consolidated fund of state. So there was a separate priority given in Section 53. So NCLT held that this separate priority is irrespective of the secured or unsecured nature of the claim. The NCLAT also upheld the views of the NCLT, the order of NCLT, and it was again held by NCLAT that Section 48 cannot prevail over Section 53. Therefore, the appellant, state tax officer, do not come within the meaning of secured creditor as defined under Section 3, subsection 30 and Section 3, subsection 31 of the IBC. Now, the question before the Supreme Court was, whether the provisions of the IBC and in particular Section 53 thereof overrides Section 48 of the Gujarat Value Added Tax 2003. Now, the Section 48 of Gujarat Value Added Tax says, for the benefit of readers, we will just read the exact clause in that, or the exact section. Notwithstanding anything to the contrary contained in any law for the time being in force, any amount payable by a dealer or any other person on account of tax, interest, or penalty for which he is liable to pay to the government shall be a first charge on the property of such dealer, or as the case may be, such person. So this says the amount payable by the dealer shall be a first charge on the property. Now, the appellant in this case is the state tax officer, and the state tax officer argued before Hon'ble Supreme Court that the books of accounts of the corporate debtor would have reflected the liability of the corporate debtor to the state in respect of the statutory dues. RP failed to examine the books of accounts of the corporate debtor, verify and include the same, and make provisions for the same in the resolution plan. That's a failure which is alleged by the state tax officer. Resolution plan does not conform to the statutory requirements of IBC and is therefore not binding on the state. Reliance was placed on Section 3, subsection 30 and subsection 31, the definitions of secured creditor and security interest, stating that the term secured creditor is wide enough to cover all types of security interest, namely the right, title, interest, or a claim to the property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and include mortgage, charge, hypothecation, assignment, and encumbrance of any other or any other agreement or arrangement securing payment or performance of an obligation of any person. Further, the state tax officer argued that just because the appellant is an operational creditor would not result in loss of the status of that operational creditor as a secured creditor. RP is to ensure that the resolution plan conforms to the parameters requirement laid down in Section 30, subsection 2 of the code. NCLT can approve the resolution plan only upon satisfaction that the resolution plan as approved by the Committee of Creditors meets the requirement of Section 30, subsection 2 of the IBC. Now, the observations of the Supreme Court in this case was, final observation of the Supreme Court was, the claim of the tax department of the state squarely falls within the definition of security interest under Section 3, subsection 31. And the state becomes secured creditor under Section 3, subsection 30 of the code. If a resolution plan ignores the statutory demand payable to any state government or a legal authority altogether, NCLT is bound to reject the resolution plan. So basically the allegation was that the NCLT has incorrectly approved a resolution plan which is not compliant to the provisions of the law. Further, the observations of the Supreme Court was that if a company is unable to pay its debt, which includes statutory dues to the government and or other authorities, there is no plan which contemplates dissipation of those debt in a phased manner. Uniform proportional reduction, the company would necessarily have to be liquidated and its assets sold and distributed in the manner stipulated in Section 53 of the IBC. So the statutory dues were not considered. So that is something which is the primary allegations, and the observation was that the COC cannot secure their own dues at the cost of statutory dues owed to a government or government authority, for that matter, any other dues. Section 48 of the GVAT Act is not contrary to or inconsistent with Section 53 or any other provisions of the IBC. Under Section 53, subsection 1B, clause 2, the debt owed to a secured creditor, which would include the state under the GVAT Act, are to rank equally and equally with other specified debts, including debts on account of workman's due, for a period of 24 months preceding the liquidation commencement date. So this is the final observation. So in this case, the resolution plan was rejected, and it was sent again back to the Committee of Creditors to reconsider, admit the claim of state tax officer as a secured creditor, secured operational creditor, and try approval of the resolution plan again. So this is what was the order. So the impact of this judgment is widespread. I have got an order in my case where I was RP in 2017. It was the first few cases of IBC. And after that, the resolution plan was approved in 2018. It was implemented in 2018. The new management took control and custody since 2018, and the RP remitted its office in 2018. Now the state tax officers of Haryana and the income tax department, they filed applications to NCLT, and those were pending for applications objecting to the approval of resolution plan, objecting to the extinguishment of their rights according to the resolution plan, although the information was available with the RP, and nothing was paid to the tax authorities. Now, based on this judgment, after 4 years, the NCLT passed an order and says that in view of the Rainbow Papers Private Limited, the RP should have considered them as secured creditor, and accordingly the proceeds of resolution plan should have been distributed accordingly. And in that order, on 22nd of November 2022, I was directed to admit the claim of the income tax department and the state tax department. After 4 years of my remitting office, the order was passed against me that I should admit the claim when the resolution plan was approved and implemented 4 years back. So this judgment, I believe some clarification will come in this regard. Otherwise, this will create some more difficulties in the IBC practice. So, Ankit, would you like to add something on this judgment? You're not audible.
Is it better now? Is it better now?
No,
I think
it's okay now. No, it's okay.
Yeah.
Every time you're restarting, it is not coming immediately. It actually has to be, I think something else to be has done.
There is a lag somewhere. So I was saying that two, three facts that were perhaps not brought to the attention of the court, which I don't see in the judgment as arguments made by the respondent. One, when we see section 53, the whole idea that there is a specific provision for government dues is something that is missing from the entire arguments. So whenever you read a section in entirety and you're saying that okay, financial creditors or secured creditors are given this priority, then other creditors are given this priority, and then you have a specific mention for government and government authorities, then that should have been taken into weight. Saying that government authorities are secured operational creditors, despite them having a separate provision in Section 53, might be a misunderstanding. Another reason that I believe that that is the case, or that was the intention, and that has been talked about since the day one, is because when you see this VAT Act, it does not have does have a notwithstanding clause, but then IBC, again, the section 53 has a notwithstanding. It starts with overriding all acts. But if you see GST, which came in, or in which was rather made a law after IBC, GST's same provision or similar provision says that notwithstanding anything contained in any other law, but other than IBC. And then it talks about the idea that the recoverability from the assessee in default will be treated as first charge. So this, I think, is something that
So
would
Ankit, I
change
think
this.
this you actually, in fact, you are raising a very valid point. In the GST, there is an exception, I believe. And like, however, in the income tax, as per some rules of the income tax, I mean, that also should be brought to our viewers. The income tax also claims that there is an automatic charge
It is
assets
almost
of.
in all the tax laws would have this clause, and GST also has it. But interestingly, GST, since it was made after IBC, and I think maybe other people can also comment in the comment box, but I understand that when these acts contain this notwithstanding clause, the one that is recent is supposed to take care of any overriding effect that is supposed to be prevented. So that is what GST has done, where GST has said that yes, it will be first charge, but but IBC will prevail. So and the whole understanding that it is not conflicting with Section 53, I believe, in that interpretation rather is faulty only because perhaps the specific provision given to government authorities was not taken into consideration.
So, Ankit, now, so I think what we can conclude, as far as the GST is concerned, any company under insolvency, the GST dues will not have the impact of rainbow paper. Is it okay, Ankit?
Yeah.
The GST dues will not have the impact of rainbow paper. This is very clear.
Necessarily, not necessarily, because the court has not said that the court has interpreted that there is no conflict. And if there is no conflict, and if there is no conflict, then the notwithstanding clause will not.
No, the question is Section 48 of GVAT Act and the GST. These are the two different things. Section 48 of the GVAT Act, it actually says that there will be a charge on the asset without any exception. Whereas in the GST, there will be a charge on the asset, but exception is IBC.
That's not provided as an exception. It says that yes, we are overriding all other laws, but yes, we are not overriding IBC when
that
GST.
means exception.
No, that means exception. But this judgment says that there is the interpretation of the Section 53 exception. It kind of dissolves that and says that there is this clause would be required only if there is an overlapping effect. So this judgment kind of interprets that there is no overlapping effect. If there is no overlapping effect, and the judgment's interpretation that government dues are also operational creditors, and therefore they would have a higher priority, and if they are secured, then there's no conflict with IBC, between IBC and GST dues will also be on the top.
No, I think again, so let's see Section 48. Section 48 says that of the GVAT Act, it says that there is a charge on the asset. Then we come to the GST, which says that there will be a charge on the asset. However, IBC will prevail.
No, it doesn't. It says that all acts will be overridden other than IBC when we say that this first charge will prevail. So the only difference in the section in the GVAT Act and the GST Act is that when GVAT Act, notwithstanding anything contained in any other law, there GST says except IBC. So that doesn't mean that the interpretation of this judgment.
I think we need to conclude this because once it is written except IBC, that means IBC will prevail.
Okay.
That actually means IBC will prevail. So there are some relevant questions here. One is from Arvind Kumar. Did court distinguish between tax recovery under implementation and tax recovery under adjudication? I think what Mr. Arvind Kumar is trying to say that one is a tax recovery, which is already the demand is crystallized and the recovery process has started, and the other is the recovery which is under some adjudication, final adjudication. So the court has not commented because we have gone through the judgment completely. Court has not commented on anything, but the facts of this case was that the demand pertained to year 2011-12. The recovery started in 2016, and we assume that this demand must have been crystallized, then only the recovery started. And then the third is that the assets were attached during CIRP. These three things have happened in this case. So it was not really an automatic application of Section 48. I mean, the court finally in the later paragraphs have said that even otherwise also the IRP was supposed to see the section and the rights of the government. That actually would not mean that it is automatic, but then yes, the courts are interpreting this judgment as a kind of automatic charge on the assets if there is a demand. Now the Annie Abraham is saying if the tax due is secured, then which asset is the security? Our answer is that all the assets would have the priority, would have a prior charge of the tax department, and from all the assets proportionately the tax would be reduced first in proportionate to the amount which is payable to the secured creditors in total. Then whatever will be remaining, then the priority of charge and the value of security interest concept would be applicable for the distribution of the balance amount. Third question is coming from Mr. Sanjeev Goel. He is saying that the Rainbow Paper, Section 53, relates to liquidation and not with respect to resolution plan. A resolution applicant may propose a varied compensation to different categories of creditor, and the law does not speak of uniform payment to all creditors. Any views? So according to our understanding, Section 30, subsection 4 says that the committee of creditors, while allocating the proceeds of a resolution plan, may consider the priority of charges and the value of security interest of each secured creditor. So in this case, the priority is the first as claimed, as held in this case. The value of security is all the assets of the company, because this charge is supposed to be a prior charge before any other secured creditor. So in case we consider this as a secured creditor, within the secured creditor, the committee of creditors can decide something which has a rationale, but the committee of creditors cannot decide that one of the secured creditor will be left completely and the other creditors would be paid differently. So there are related issues like 30 subsection 4 is one. Secondly, for taking votes of unsecured creditors also, the COC has been allocating some proceeds to unsecured creditors. Even we have seen that the COC has actually been allocating more to working capital lenders as compared to their value of security interest. That is to facilitate the approval of the resolution plan. So it is very correct. Mr. Sanjeev Goel is saying that had it been considered, now think of a situation that this particular claim would have been considered as a secured operational creditor. It would have gone to the committee of creditors. The committee of creditors would have decided something, that some lesser amount may be offered to them because of other considerations which are rational, which are according to the primary mandate that the committee of creditor will try to resolve the cases and will avoid liquidation. If that would have been the consideration for allocating little lesser amount to secured operational creditor, I think that would have been acceptable by the court. So the last question on this particular subject, which I am reading because this is a very, very important judgment, and even we are taking some time on this judgment because our listeners are interested in listening to this. They are raising questions, and while we have many more judgments of, probably we will not be able to finish all the judgments in part 2. So we will talk of landmark judgments delivered by Supreme Court in 2022. So Mr. Sanjeev, I think we have given our view on this. So we are now moving on to the next question, which is Jai Narayan Gupta has asked how the reversal of clock after 4 years after implementation of the resolution plan would be executed, whether there is no limitation provisions, what are the do's and don'ts of the NCLT in this regard. So my observation is after 4 years of approval of the resolution plan, like one part is that the directions to the RP. So RP has approved, and what action I have taken, I have, as directed to me, I approved their claim as a secured creditor. Now, the next action with the income tax department would be that income tax department would claim it from the resolution applicant, successful resolution applicant. Then successful resolution applicant will file an application to adjudicating authority based on the Ghanshyam Mishra and also multiple other judgments in 2022. After Ghanshyam Mishra, a similar judgment has also been given again, that no such claims can keep on coming on the resolution, successful resolution applicant. So based on that, even in Ruchi Soya also, there was a much larger discussion on this part. So when that particular adjudicating authority will take a decision that the successful resolution applicant is not supposed to pay anything over and above the amount already paid, then there would be a separate scenario. Then the income tax department might even reach out to the those creditors who actually have been given the proceeds, like the secured creditors, like the banks. So let's see what final action comes, because I had only two options: one, to file an appeal against the order of NCLT. Then I was having a difficulty, like who will spend the litigation cost. So I simply honored the directions and I admitted their claim. Now, Mr. Sanjeev Goyal again is asking a question, like also as per the BRLC, the BRLC recommendation, and also as per the bill proposed in the Lok Sabha, it is clearly mentioned that in order to meet the intent of IBC, any kind of government, central or state, dues shall be ranked lower to all other creditors. So what we understand, as I said, that some clarification or some amendment would be required to circumvent the impact of this judgment of rainbow paper. In case this would not be done, then the order that I have received after 4 years, those kind of orders would be many and will create a new kind of litigation in the IBC. Jainarayan Gupta further asked that if there are no specific provisions in any taxing statute like in GVAT, then rainbow paper judgment can be differentiated. Of course, yes, if there is because the primary argument of state tax officer was section 48 of the GVAT Act. If there is no such provision in any tax law, then the charge on the assets of the company would not be valid. Therefore, the department will continue to be an operational creditor, but will not become secured operational creditor. That would be a totally different scenario. So Vakil Harvinder is asking a question. Section 48 of the Gujarat Value Added Tax 2002 provides that the first charge on the property of a dealer in respect of any amount payable by the dealer on account of tax, etc., under the Act cannot prevail over Section 53 saying, but this judgment says that Section 48 definitely doesn't prevail upon over Section 53. However, the judgment says that secured creditor. If a secured creditor is an operational creditor, it would not mean anything. Now, to give an example, like if there is a person who has supplied goods to a company, and against the supply of goods he has taken a collateral security, or he has taken a security of the some shares or some investments or some mutual funds of the company. Now, since he's an operational creditor, does it make a case to take away his right of being a secured operational creditor? According to my understanding, he is a secured operational creditor. In fact, much before this rainbow paper judgment, we have considered some of the operational creditors as secured operational creditors, like the electricity department dues, like the state industrial development corporations dues and their lien on the assets. We have considered them operational secured creditors, and we have allocated the amount to them, which is pari passu to the secured financial creditors. So I think we have we see, like, I want to understand the Section 53 is being interpreted differently. They're saying if the amount due to the person, if any person is secured A and B, so that is what is the analysis of this order. It doesn't say Section 53 says that Section 53 has to be interpreted differently, because the secured operational creditor falls above, along with the secured financial creditor. That's what it is, the meaning of this judgment. And to some extent, it may prevail. However, when there is a separate space, when there is a separate priority for government dues, that has not been considered by the, because now I think the government will come out with an amendment, and as I think as Mr. Sanjeev Goyal is saying, that the central government has made some kind of draft bill, and they are clarifying it. So we will wait for the clarification. The Justin Zospom, whether liquidator should attend the assessment proceedings initiated by Income Tax Department during liquidation period, assessment related to prior to CIRP period. Certainly, yes, the liquidator is supposed to provide information, whatever information he has, to the tax department, for any department, because the assessment proceedings is not a legal proceeding. Assessment is just seeking information to verify your return which you have filed. And that is the duty of the RP as well as the liquidator to provide information to the tax department. Now, I will give another illustration. Like, suppose in one case, the liquidation value of the company 100 and the total claims in that case is 90. In that case, in case you would not, in case the liquidator will not provide information to the income tax department, then the income tax department will make an assessment on ex parte basis, and the demand may be much more than what normally it should have been. So therefore, the additional amount of ₹10, which would have gone to the shareholder, that would have gone to the tax department. So that's not the duty of the liquidator to compromise with the rights of the stakeholders. So the liquidator is supposed to attend the proceedings of the income tax department. Law Obroy is the email where we have received a question. Can you please convey the case which has been reopened after 4 years, and what is the way forward? The name of the case is Recorders and Medicare Systems India Private Limited. It is a Chandigarh bench case, you can see, and the date of the judgment is 22nd or maybe 21 of November 2022. Sir, the problem has come since it is not included in IM. If it is included, then judgment may have been different. Is it correct? my understanding is that in the rainbow paper, in case it could have accepted as a, because see, the concept is not whether it should have been included in IM or not. The concept is that the creditor has not been admitted as a secured operational creditor. Honorable Supreme Court is saying that this particular creditor, state tax officer, should have been admitted as a secured operational creditor. The secured operational creditor has not been admitted. The secured operational creditor has not even is a kind of that is the non-compliant resolution plan. The person has this creditor should have been admitted as secured operational creditor. Even if this would have included in the IM, even if this could have been included in IM, the difference is the secured operational creditor and unsecured operational creditor. That is the difference. Arun Kumar Srivastav is asking, am I audible, Ankit? Because if my computer is again and again giving me an indication that your internet is unstable. You are still not audible. I think your computer is under some difficulty. When you start speaking after unmuting.
So am I audible now?
Yes, yes.
So I'm saying that you are audible throughout. There is no problem.
So Arun Kumar Srivastava was saying, as per Schedule 3 of the Companies Act, VAT dues are not shown as a secured liabilities. This we have to see. We have not checked up with the under the as not as a, but the I believe this particular section, Schedule 3 of the Companies Act, would be applicable to winding up proceedings under the Companies Act, whereas this particular judgment is under the Insolvency and Bankruptcy Code. So there may be a difference, and it should be different. I've posted one more query. Please share your views. In fact, I've done that. Yoginder Singhal is saying, in case of liquidation, GST department filed claim as an operational creditor. In that case, GST to be paid proportionately as per secured creditor or not. Yoginder ji, like as Ankit has said, you also please see the dues of GST under insolvency. In case the GST law says that the GST dues will have a priority other than IBC. So IBC will prevail. So the GST dues will continue to be unsecured operational creditor because the GST law itself has given this exception. Mr. Manmohan Jindal says that my concern is when notice for submission of the claim is published, GVAT had submitted its claim and where it was allocated at that time. So in this particular case, in Rainbow, the GVAT claim was not, it was submitted, but it was considered as the government dues. It was considered as government dues. It was not considered as secured operational creditor. This is what I understand from the reading of the judgment. Kanekal Chandru says, does income tax law also have any notwithstanding overriding clause to treat its dues as secured operational creditor? So, Mr. Chandrasekhar, it is the income tax law has started claiming that as per the rules, they have given certain rules that they also have rules which says that in case of any recovery, all the assets of the taxpayer would have a charge for the income tax department. So the income tax department has not given that exception as the GST has given, because in case you would see, the GST was also implemented in the same year when the IBC was implemented. So when both the acts were being drafted, so they would have considered that the government dues would take the fifth priority. So that was appreciated by the people who were drafting GST. But as far as the income tax department or state tax departments are concerned, so these are different. I mean, this actually will have to go through the interpretation of Section 53. Mr. Sudarshan says any review filed against this while examining Section 48 of GVAT, holding for other government dues appears far stretching. As we said, that state tax departments of almost all states has similar sections, similar clause. The GST, as Ankit has clarified, that GST has an exception to IBC. Income tax department has already started claiming, as per the rules, they have a lien on the properties of the company. So this may have far-reaching, but as I think we have also got an indication that the draft bill actually will clarify that the government dues will have the same priority as given in Section 53, irrespective of the attachment of the assets or no attachment of the assets. Because on the other hand, we see that the custom department has a charge on the, I mean, we'll come to that judgment. When somebody import and it doesn't pay the custom duty, as per the Custom Act, the custom department will have a lien on the goods, and the custom department has a right to sell the goods to recover their custom duty. However, in the case of ABG Shipyard, the Supreme Court has very clearly held that the custom department will not have any lien on the goods. The custom departments will hand over the goods which were lying at the custom station to the RP or to the liquidator, and the liquidator will have all the rights to sell those goods, and the custom department will file their claim to the RP. And this judgment of Supreme Court, and further we are getting many other orders also where the goods lying in the custom station without the payment of the custom duty are being released to liquidators and the RPs. Kantapudi Venkata says that I think this rainbow judgment has relevance only in case of liquidation and not in CIRP. This rainbow judgment was a CIRP judgment. It was a resolution plan which was rejected by Supreme Court. It was not a case under liquidation. It is a case under resolution plan, and the Supreme Court has finally held that the resolution plan which was approved by NCLT and also NCLAT was not in accordance to law. So they finally referred back this resolution plan to the Committee of Creditors to make another effort for approval of the resolution plan after considering the state tax officer as a secured operational creditor. That was the direction in the Supreme Court order. The rules cannot override and go beyond the act. This is again a question from Vakil Harvinder. So as far as the income tax department is saying, the income tax department are saying that they have a lien on the assets of the assessee, maybe as per the rules or as per the act. If they has lien, if their lien is accepted, then they also become secured operational creditor. The rules are not accepted when it is in contradiction to act. Otherwise, rules are accepted. So, Ankit, we move on to because this was an important judgment, so we thought that we should actually continue with this. So, going forward, let us see, is there any other judgment, I don't think we have taken up all the questions. Anything which comes in your mind on Vidarbha, Ankit, on Rainbow?
No, I think we should move forward.
So we are moving on to the Ruchi Soya Industries Limited versus Union of India, and this judgment was given on 17th of February 2022. It's a kind of landmark judgment, like what exactly it says. Again, this is a case where some notification dated 13th of June 2022, which was issued by Department of Revenue, Central Board of Tax, Central Board of Excise and Customs, Union of India, where a tax was imposed on imported goods. So in those days, the palm oil was supposed to be was being imported by many parties in India, and then the government came out with a notification, and there was an import tax that was levied, and the Ruchi Soya imported 1,647 metric tons of crude palm oil, and which was covered under this notification, and the bill of entry was showing it was for home consumption. Ruchi Soya challenged was dismissed, and the an SLP was filed before Supreme Court against that application of that notification to the goods imported by Ruchi Soya. So this was a case. So in this case, the next action was when it was when this case was being heard, even the Supreme Court said in like that was in May 2012, the Supreme Court said that as an interim order, it was directed to Ruchi Soya that you deposit the amount which is being sought from you as per the notice with the concerned commissioner. Then we will stay the recovery process on you. So this is what was done. The Ruchi Soya deposited that amount which was sought from the Ruchi Soya. I'm not sure whether it was the full amount or 25% amount or 10% or 20%, that I'm not sure. But the amount was deposited to seek that stay from the Supreme Court. And that stay was continuing since 2012. That stay was continuing since 2022. Section 7 application against Ruchi Soya, the NCLT granted, NCLT ordered the CIRP. Then in September 2019, the resolution was also approved. In September 2019, the resolution was also approved. Now, this particular matter, which was stayed in 2012, this came up for hearing in 2022. And in that hearing, the disposal was done in the following manner. Now, the case is there was a recovery process started by the commissioner from the customs department because of some imports, and the government levied some tax. Ruchi Soya was saying that this tax is not applicable to them as per the notification. Now, this is the question whether on date on which resolution plan is approved by NCLT, all claims stood frozen and no claim which is not part of the resolution plan would survive. So I was referring to this judgment when I was saying that in Rainbow, when I admitted a claim of income tax department and state tax department, and then that department will reach out to resolution applicant for that payment, that resolution applicant, successful resolution applicant will reach out and will show this kind of Ghanshyam Mishra and Ruchi Soya, and will say that all claims would not survive. No claim would survive after this particular date. Now, the appellant in this case, again, like Ruchi Soya, and now the Ruchi Soya is being argued on behalf of the successful resolution applicant, which is Patanjali. So Patanjali argued that we have acquired this company, Ruchi Soya, and the applicant cannot be suddenly faced with undecided claims after the resolution plan is submitted, so that the resolution applicant knows exactly what has to be paid in order to take over and run the business of the company. The legislature clarified that once a resolution plan was approved by NCLT, all claims of government, state government, local authorities, including tax authorities, which were not part of the resolution plan, shall stand extinguished. The legislative intent behind this is to freeze all the claims so that the resolution applicant can start on a clean slate and is not flung with any surprise claim. Further, it was also clarified that the word other stakeholders would squarely cover central government, state government, or any other authority. The 2019 amendment is declaratory and clarificatory in the nature and therefore retrospective in operations. Now, the observations of Honorable Supreme Court in this case is, again relying on Ghanshyam Mishra, held that the claim which was made by Union of India was not part of the resolution plan and hence do not survive, and directed that the amount. No, it's a very kind of bold judgment. At that point of time in 2012, some amount was paid to get that stay on the recovery process, maybe 25% or 50%. I'm not sure. Now, no claim was filed by the department because of the matter was already pending before the Supreme Court and the tax was almost paid. The claim was not filed. Now, when the claim was not filed, this Ruchi Soya went into a resolution, and now the new incumbent in charge, the new management is saying that this claim for which the matter is pending before Supreme Court was not filed by the department. Therefore, whatever we have paid to get that stay should be refundable to us. And the judgment says yes. The judgment says yes, even if the claim was disputed, if the amount, the petition, the matter was pending before Honorable Supreme Court, the claim should have been filed by the Customs Department. So this is a great judgment, like what normally a department would have thought that whatever we raised as a demand was paid by the assessee on the direction of the Supreme Court, and it was pending since 2012 in the Supreme Court. After 10 years, now the Supreme Court is saying that this amount which was paid in 2012 should be paid back, should be refunded along with the interest accrued. So it was a huge amount. This is one sense which says that this was a windfall for Pitanjali, and this amount, in fact, was huge when it comes back from the department. The judgment is significant as the Honorable Court made it clear that any authority which have made any claim against the company concerned but failed to bring it to the notice of the resolution professional cannot be allowed to raise such demand at a later stage. Further observation says that all claims made by one or any state or central government or any local authority so far which was not part of the resolution plan has no leg to stand in the eyes of law. If any amount is deposited by Limited in a similar manner in such which were not part of the resolution plan, Ruchi Soya Industries Limited is entitled to claim such deposit along with interest from the date of the deposit, provided such claim was not part of the resolution plan. So this judgment, Ankit, is actually a kind of mind-blowing judgment. So this has given a huge windfall to Pitanjali, to Ruchi Soya. That also probably is the reason that the shares of Ruchi Soya are just leaping.
No, I agree. So this is definitely another comfort for resolution applicants for larger cases under insolvency, where this kind of protection is always important. Also brings more clarity on the idea that the government authorities have to be vigilant and they have to file their claims. So in the recent case of like Sargam, based on the new regulations, we sent out emailers to all regulatory authorities for sending us the claims. And interestingly, I believe that this word is spreading. So we have got claims from almost, all government authorities having a demand or which was demands which are reflecting in the balance sheet. I think this culture that was prevalent earlier that they will simply not file their claims is anyways ending now.
See, we have received another question, and which is from Sanjeev Goel. Don't you think Ruchi Soya judgment is in contradiction with Rainbow paper, since in Rainbow the GVAT department also failed to file the claim and hence was not part of the resolution plan? Ruchi Soya came before and the Rainbow paper came later. So the Rainbow paper definitely was on, because see, in this particular case, the resolution plan was approved, but finally it was pending before the Supreme Court, so it was rejected. The approval was rejected. The GVAT department, in this case probably filed the claim. This is what is my understanding. The GVAT department in the case of Rainbow, I think, filed the claim, and it was also during the CIRP. The asset was also attached during CIRP. So it is not a case that the claim was not filed. However, in Ruchi Soya case, the customs department, where the additional levy was supposed to be charged on import of palm oil, that particular claim was not filed. Probably the department thought that the amount has already been deposited, but that was deposited on as a provisional amount. So that was not considered to be attributed to the payment of tax. So there are 2-3 hands which has been raised. Can we take up these questions, Ankit? But then how do I reach out to them? There is a Anita Kulsresht. She has raised a hand. Can I think no? I think she has now. I think these questions have already been asked. The people who have, or I can still seek in case she can ask a question. So Anita ji, you can raise your question so we can answer that.
Raised much before for the Rainbow case, and I think the enough discussion has taken place and my questions have been asked.
Thank you. So again, the time is over. We have many more judgments which are again exciting, like Ruchi Soya and Rainbow. We'll come back again with the same subject as part 3 again on coming Saturday at 11 a.m. Stay connected with us. It is our pleasure to share our experiences. So we conclude, Ankit, or you would like to add anything? No, you're again not audible.
I think we should conclude, and I think we should then take up more cases next time. Rainbow judgment definitely deserves the time that we gave to it today. And let's hope that this spanner in the whole IBC wheel at least vanishes. There are many other spanners just spoiling the show, but then this one is a critical one.
Thank you very much, participants. Again, looking forward for the next Saturday, 11 a.m. Thank you.